Josh Winger practices law in Maryland and the District of Columbia. He is a member of the Maryland, D.C., Prince George's County, and Anne Arundel County Bar Associations. Joshua received his JD cum laude from the University of Baltimore Law School in 2007 and his Bachelor's of Arts Political Science in 2004 from the University of Maryland, Baltimore County. Joshua began with the firm in 2002, first as a law clerk and now as an attorney. Joshua has worked for multiple trial judges and an appellate judge in Maryland Judiciary. At Byrd, Joshua primarily handles estate planning, elder law, post-mortem administration, and contract litigation matters. Joshua served for 4 years on the board of directors for the Anne Arundel Senior Services Provider Group, Incorporated, and has served as its treasurer for 3 years. In 2018, Joshua was selected to serve a 2-year term as a section council member for the Maryland State Bar Association Elder Law and Disability Rights section. Joshua has a strong desire to help others and has volunteered for multiple local outreaches. He is married to his beautiful bride, Lindsay. Joshua and Lindsay have 3 wonderful children, Luke, Grant, and Max. Joshua enjoys long distance running and is also a passionate fan of soccer and the arts. Attorney Winger, thank you for joining us today for this important discussion on when and why should I file for Medicaid. I will now turn this session over to you.
Specifically, what we'll be talking about today is long-term care Medicaid. There's really 2 kinds of Medicaid as I pull up my information here. There's long-term care Medicaid and community Medicaid. Community Medicaid is for people who are healthy enough to not need to be in a long-term care facility. There's many kinds of community Medicaid. The most recent version is what came about during the Affordable Care Act. But the point is that's really government health insurance for people who are not in a healthcare facility. But what we'll be talking about today is long-term care Medicaid. That's for people who are in a skilled nursing facility. So that's what we'll be talking about today, is the basics of that. So of course, one of the most common questions people say is, who pays for long-term care? That's a huge issue, because as we'll talk about, long-term care is incredibly expensive. And unfortunately, many people like you and I are not really, don't really have the funds available to pay for long-term care, certainly not for a long period of time. So there's a lot of kinds of needs for long-term care, and we'll be focusing on some of them here today. So paying for long-term care, you break it down, there's really 3 kinds. The top one there is long-term care insurance. If you're fortunate enough to be able to pay for long-term care insurance and fortunate enough to have qualified for long-term care insurance, that is generally the best way to pay for long-term care, because long-term care insurance, most policies, they will pay for in-home care, they will pay for assisted living, and they will pay for skilled nursing care. So they're the most flexible in that they will pay for any of those 3. And of course, long-term care insurance, the other really important, excuse me, is that they really, they have inflation riders, so that if you get a long-term care insurance policy, for example, in the year 2000, and it pays for $100 a day of care, and it has an inflation rider, then it means it's worth more than $100 here in the year 2021. It's $100 plus inflation that has occurred over the past 21 years since you got the policy. So it's also very important that a long-term care insurance policy have an inflation rider as well. It's one of the very important things to have in it. Second one, of course, is private pay. That just means you're paying for it yourself, or at least your family's paying for it. And that is, of course, what many people cannot do, at least for a long period of time. But if you're fortunate enough to be able to private pay, of course, practically, most facilities will accept you paying from your own personal funds. But the one we'll be focused on today is Medicaid, which is also a shortened version of the term medical assistance. And again, specifically, we're talking about long-term care medical assistance, or Medicaid, today. Huge difference, for example, between Medicaid and long-term care insurance is, for the most part, Medicaid, long-term care Medicaid, only pays for skilled nursing facility care. If you're in for example, if you're in the Prince George's County area, some examples of Medicaid long-term care facilities are Villa Rosa in Mitchellville. There is Future Care in Largo. Going east in Anne Arundel County, there is Crofton Care in Crofton. There's one in Waugh Chapel, but so we are not talking about assisted living. For the most part, Medicaid does not pay for assisted living, and for the most part, Medicaid does not pay for in-home care. There are some very few waiver spots where you can get an approved plan to be covered at an assisted living or in-home care, but quite frankly, there's very few assisted living facilities that are willing to accept Medicaid. And also for if it's going to be at an assisted living or in-home care, Medicaid has to approve a specific plan of care for you in order for Medicaid to pay for it. So the vast majority of people who are on long-term care Medicaid are in skilled nursing facilities, which is really the highest level of care. A common misconception is people confusing Medicare versus Medicaid, and those are absolutely not the same thing. Most people who are 65 or older and entitled to Social Security, or who have been declared disabled through the Social Security Administration for at least 2 years, have Medicare. That is not the same as Medicaid. It's very unfortunate that they have very similar names, but that's just unfortunately the way it is. But Medicare and Medicaid are not the same thing. Medicare, if you go into a skilled nursing facility, Medicare will pay for up to the first 100 days, but under very specific circumstances. That's if you are admitted to a hospital for 3 midnights. Where you are actually admitted as a patient to the hospital for 3 midnights, midnight passing 3 times, of course, and then you enter into a nursing home, which is the kind of common term for what the government calls a skilled nursing facility. So when I'm using the term nursing home, I am not talking about an assisted living. I am talking about a skilled nursing facility, which is the term the government uses. But anyway, from the 3 midnights at a hospital, then within 30 days after being discharged from the hospital, you go into a nursing home, or again, what the government calls a skilled nursing facility. So Medicare will pay for the first 20 days in full at the skilled nursing facility. Then Medicare pays a reduced rate for the next 80 days. So there in parentheses is, as of this year, 2021, you, the patient, are responsible for $185.50 per day of each of those 80 days. And frankly, our firm sees that it's really that period of day 21 to day 100 when a patient is getting a bill from the facility for $185.50 a day. That's when it really hits home that for a lot of patients that they do not have a way to pay for this long term. That first 20 days, everything feels great, and because the Medicare is paying for it. But then once day 21 kicks in and the facility says, okay, where's the money coming from? And a bill starts coming in for that approximately $185. That tends to be when a patient or the loved ones contacts our firm to discuss Medicaid. So again, after day 100, Medicare absolutely will not pay for any of the long-term care. And the patient has to be given 24 hours notice of when Medicare will terminate. So of course, it's possible that the 24-hour notice might incorrectly not be sent, but that's generally, they're pretty good at giving notice at the 24-hour notice, because that has to do with the facility getting paid. So the facility is normally pretty good at giving the 24-hour notice. There's the technical requirements for qualifying for long-term care Medicaid. There's the being 65 or older, or blind, or disabled. And there's being a U.S. citizen or a resident legal alien, commonly called a green card recipient, and to be a Maryland resident. Now, Maryland resident, that is quite frankly quite easy. It's as long as you're a Maryland resident for 1 day, you can qualify as a Maryland resident. Here, I mean, our office is in Bowie, Maryland. It happens very often that people start as a DC resident and then they move to Maryland for 1 day, or they're a Maryland resident and they move to DC and they want to be in a DC facility. So those technical eligibility ones are pretty easy, or there's really no debate on those. It's just a straightforward criteria. Medical eligibility is where things get far more difficult. So there's the first one, which is generally the most common way that people get on long-term care Medicaid, is where somebody needs, quote, hands-on assistance, end quote, with what's called activities of daily living. If you look into this area, you'll see the abbreviation ADL all over the place. That stands for activities of daily living. So the most common people who are on long-term care, they need help with at least 2 of those activities of daily living: bathing, dressing, transferring from sitting to standing position, walking, eating, and toileting. This is what's called skilled nursing care facility level of care. However, there are some secondary ways of qualifying. Somebody who needs supervision, not necessarily hands-on assistance, but supervision with at least 2 of those ADLs, but they have cognitive deficits, and they need assistance with at least 3 instrumental activities of daily living. So those are IADLs, and those are listed there: telephone use, money management, housekeeping, and medication management. So what that is getting into are people who have some sort of dementia, and so it's an extremely difficult thing, whether somebody has progressed enough or regressed enough, depending on how you look at it. If they have regressed enough in their dementia that they meet that second criteria, because oftentimes somebody with dementia are able to, go from sitting to standing and walking and eating. And by the way, eating means fork to mouth. It does not mean standing at a stove. Eating means fork to mouth. So unfortunately, a lot of times somebody with dementia can meet those activities of daily living, and that right there can unfortunately disqualify them from Medicaid. So has the dementia regressed so much that they need at least supervision of 2 of those ADLs, and they need assistance with at least 3 of the IADLs. And the last one there is probably the least common that we see, but it's somebody who needs supervision of at least 2 ADLs. Then they have various behavioral problems, and those are listed there, such as hallucinations, aggressive behavior, and socially inappropriate behavior, or self-injurious behavior. So each state has their own program or office in place to evaluate people who might meet any of these criteria. So the medical eligibility, that is, there can be debate as to whether somebody meets it or not. There can be appeals if the state says that they do not meet that level of care, but that's a pretty difficult area there, meaning it's not as easy to meet those as it is to meet the technical eligibility. So where law firms like our firm come in are for the financial eligibility. So there's income eligibility and there's asset eligibility. So income eligibility, that frankly for most people is pretty easy. Your monthly income just needs to be less than what the cost of care is for skilled nursing. And as we'll get into in a little bit, the average cost of care according to the state of Maryland for long-term care is more than $10,000 a month. So very few people have more than $10,000 a month in income. so that meeting the income eligibility for most people is not very hard. The asset eligibility is where it's very hard for a lot of people, because the applicant can only have $2,500 to their name, with some exceptions that we will go over, but essentially they can only have $2,500 to their name in bank accounts, stocks, so on, as of the first day of the month in which the Medicaid application is filed. So to dig into a little bit more about the assets, a single person is able to keep $2,500. Pretty straightforward, harsh, but at least it's straightforward. A married person, in Medicaid lingo or Medicaid terminology, the ill spouse who is in a skilled nursing facility is what's called the institutionalized spouse. And if the spouse is still living and they're still in the community, then the healthy spouse is who's referred to as the community spouse in Medicaid terminology. So the community spouse is allowed to keep a minimum of $26,076 and a maximum of $130,380 as part of the qualification process for the ill spouse or the institutionalized spouse qualifying for Medicaid. Now for income, sometimes it's the case, for example, where the ill spouse has far more income than the healthy spouse or the community spouse. So it could be that if the ill spouse who has far more income, it could leave the healthy spouse destitute out in the community without money to pay the family's mortgage or the rent or the utilities. So what they have is, see all these M's and an N and an A, minimum monthly maintenance needs allowance on the left side of your screen there. What that is if the healthy spouse or the community spouse does not have enough income, if they've got less than $2,155 a month in income of their own, such as through Social Security or so on, and some of the ill spouse's income is allowed to be applied or given to the healthy spouse to get the community spouse up to a total of $2,155 a month. The maximum income in order to for any money to go from the ill spouse to the healthy spouse is $3,259.50 a month. Now, if the community spouse, frankly, is fortunate enough to have a large pension and Social Security and has whatever $5,000, $6,000, $7,000 a month in income of their own, then they can have all of that. These figures here on the left are only if monthly income is being taken from the ill spouse and being applied towards the healthy spouse. So now to get into some exceptions, if you're fortunate enough to be a homeowner and you own your home that you live in does not count towards your $2,500 asset limit for qualifying for long-term care Medicaid. Really everybody, at least in spirit, even if it's not realistic in some situations, everybody who applies for long-term Medicaid would like to return home if circumstances were ideal. So specifically, if you're a single person, your home is exempted if on the application you state that you at least intend to return home. That way it remains your residence. So that's what that's about there. If a single person passes away as the last owner on the deed to their home, then that home will be in the single person's estate when that person dies, and it will be subject to a Medicaid claim against that deceased Medicaid recipient's estate. Now, with a married person, a bit more complicated. The home is exempt and there's no right of recovery if the ill spouse passes away before the community spouse, meaning the healthy spouse survives the ill spouse, because then at the very least on the deed to the home, the community spouse will still be a living owner on it when the ill spouse passes away. Now, as part of the Medicaid process, there is an opportunity during the application process for the ill spouse to be taken off of the deed. The rest of that information there, though, you'll see on the screen, that has to do with what happens if the surviving spouse or the healthy spouse passes away before the sick spouse or the ill spouse. The ill spouse, essentially approximately 1/3 of the healthy spouse's estate is required to be used for the purpose of the ill spouse in a trust form or in the form of Medicaid payback. That's something that unfortunately occurs when the healthy spouse dies before the sick spouse or the ill spouse who is in the skilled nursing facility. So if you're single or married, some exemptions for the home is if you have I understand this is not extremely common, but if you have a minor child who lives in the home when you're, then that home can be exempt from Medicaid's claim process. Or if you have a disabled child that resides in the home can be exempt. And a bit more complex exception is if you have a child who resides in the home for 2 years prior to a parent's admission to a skilled nursing facility, and the child actually provided care that allowed the parent to at least remain in the home for a while, as opposed to going to the skilled nursing home or skilled nursing facility sooner, then the house can be transferred to that caregiving child without penalty to the ill parent. And if a sibling is a joint on the title with the ill recipient and resides in the home for at least 1 year prior to admission, the home can often be transferred to the sibling without penalty. So that's kind of a brief overview of the home exceptions there. Some other exceptions, if you own an automobile, every situation I've really seen is that the cars are exempt. Every once in a while, I get somebody who has the hypothetical of what if somebody has, 10 cars and they're a Jay Leno type person who's got a garage filled with collectibles. Quite frankly, I've never seen that as part of a Medicaid application. So I don't know. I've never seen that tested, when push comes to shove, but I've never seen Medicaid go after any automobile that a recipient has had. Personal belongings, so that's just talking about, your personal effects you have around the house, your couches, so on. Again, I've never seen Medicaid, really dig into that deeper. I've never seen Medicaid ask, hey, does somebody have some, artwork on the wall and let's go get that artwork valued, for example. I've really never seen Medicaid push too far, but I suppose if you have a Picasso on the wall, so to speak, that could be, Medicaid could theoretically go after that. Home improvements. If you are about to go on long-term care Medicaid, one of the things that you can spend down your money on, so say, for example, you're a single person and you've got $100,000 and your home really needs a lot of improvements, you could spend, to exaggerate the point, you could spend all $100,000 on fixing up your home so that you now have $0 and you have gone from $100,000 not qualifying to having $0, meaning you have less than $2,500 and you qualify for Medicaid as far as the assets go. There's certain irrevocable prepaid funerals that can be obtained for both the applicant and the applicant's spouse. Life insurance is a very, very tricky one. First off, term life insurance policies do not count at all because a term life insurance policy is worth $0 until it actually pays out, because a term policy could always go away if the insured person lives past the term. Like many people have, for example, a 10-year term life insurance policy, and if you live past the 10 years, then the life insurance policy is worth nothing. Where life insurance can really get in the way is somebody who has a whole life policy that's really traditional, or sometimes a universal life insurance policy. And what that is, like a whole life policy, has a cash value, basically roughly as equal to the amount of money that you've paid for the life insurance policy, sometimes the interest that's accrued on the life insurance policy, and so on. Whole life policies normally are a disqualifier for Medicaid, because if you have a whole life policy that you could cash in right now and get $20,000 or $100,000 or whatever the amount might be, and that of course it might be a taxable event, cashing in the life insurance policy, but Medicaid doesn't care. They say cash it in and do something with that money. Assets that are used to increase the community spouses MMMNA. We went over that a couple of pages before. Those are exempt. Health insurance, for example, to cover things that Medicaid might not. So Medicaid planning, a large part of what our firm does is helping people plan in advance for Medicaid. If there's me one takeaway that you have from today, it's to understand that whenever somebody applies for Medicaid, there is a 5-year look back period that the government can look back to see if you have given anything away for less than fair market value. Easy example is, did you sign your house over to your child and then 6 months later apply for Medicaid? That's a big no-no. Unless, of course, there's the whole caregiver exception, but for the most part, somebody just says, I have a child who's completely healthy, lives in the home, didn't help me provide care for me, or even worse, the child doesn't even live there. That you just want to sign your house over to the child, can't do it. Unless, again, at least the 5-year look back period passes before you apply for Medicaid. Or somebody says, I've got $100,000 in the bank and I just want to write all $100,000 to my child and then apply for Medicaid tomorrow. It doesn't quite work that way. There are some strategies that we could go over that might save some of that $100,000 in that situation, but normally not all of the $100,000. Over a compensated transfer, that there is no penalty for that. An easy example is if 6 months before you are ill, you sell the house your home on the fair market value, or on the open market for a fair market value. Like say if the house really is worth $200,000 and you actually sell it for $200,000, then you got fair market value for it, or full value in return. The question is, though, is what do you do with the $200,000 that you got for selling the home? Uncompensated transfers are, again, like I mentioned before, like if you sign your house over to a child who does not qualify, or if you just plain write a check for $100,000 or to a child, and in parentheses there, that's going over. So a lot of people bring up the $15,000 per year gift rule that the IRS has, where IRS allows you to give $15,000 per person per year to anybody that you want and not have to report it to the IRS. That is not a Medicaid rule. That rule works for the IRS for gift taxes. It does not work for Medicaid. That's the easy explanation there. There is far more detail there. Like, for example, if for the last 20 years you have given away money, every year you've given away $15,000 to every single family member, and this is, 15, 20 years before you ever got ill, and sometimes those gifts can be excused because you did not do those without ever thinking you would be going on Medicaid, long-term care Medicaid, where it is absolutely 100% a problem, is if you have a stroke and then you immediately start writing $15,000 checks to all of your family. That's just not going to work, because there is no argument that you had a course of conduct or a pattern that you were doing that originated before you ever got sick. So the penalty period is not a dollar penalty. Like if you give away something for less than fair market value within the 5 years, you don't get a bill from the state of Maryland. They just say there's a period of time that they will not pay for your long-term care. So like you see down there at the bottom of the page, the current cost of skilled nursing facility care, according to the Maryland Department of Health in 2021, is $10,130. So going back to the $100,000 example, if you were to write a $100,000 check to your daughter and then try to apply for Medicaid the next day, Medicaid would see that you wrote a $100,000 check for your daughter the day before you applied for Medicaid. Medicaid would divide that $10,130 into your $100,000 gift. And I'm just going to do my math here. That is about 9.87 months. So what that would be is essentially for 9.87 months, state of Maryland says the Medicaid program will not pay for you for the next 9.87 months. You've got to figure out a way to pay for your long-term care because Medicaid will not pay for you. And then if you qualify otherwise, when your penalty period is over, then Medicaid would start paying for you after that period. So that's anyway, so that on the way down at the bottom, it talks about when the penalty period starts. So it does not start until the first day of the month in which you've actually applied for Medicaid and you're otherwise eligible. So it's very important that if you are doing any kind of gifting strategy, that you work with a knowledgeable law firm to do it correctly. So asset preservation. So these are some of the list of things that a lot of law firms do. Most of these ones are ones that our firm is at least somewhat involved in. For example, a life estate without powers deed. That's one our firm does for a lot of people, because a lot of people come to us and say, Josh, if I have to spend every single penny I have on my care, oh well, but I would like to at least preserve my home. So a lot of people make a life estate without powers deed at least 5 years in advance before they even possibly have to go into a skilled nursing facility, so that the state of Maryland would not be able to put a lien on your home after you pass away. The big thing about without powers is once you do that deed, you give up the right to change that deed. Certainly you cannot change it on your own. You and the beneficiary, or plural beneficiaries, you name the deed, could combine together to sell the home, but the beneficiaries would get most of the money from the sale. So the big thing about life estate without powers deeds is you really should not do that deed unless you are committed to keeping that house the rest of your life. If you say, hey, I'm thinking about selling my house next year or in 2 years, life estate without powers deed really is not for you. An irrevocable pure grantor trust, that's somebody who not only wants to preserve a home, but they have stocks or some accounts. Maybe they have also a rental property that they want to preserve. Again, if you put things into a proper irrevocable pure grantor trust, and if at least 5 years pass, then those assets do not count as yours for the purpose of qualifying for Medicaid. Perhaps the income would, such as if you have a rental property, but it depends on how the trust is structured. Some people want to keep their income. Some people don't want any of it. They don't want the income or the principal. Long-term care insurance policies. Of course, our firm is not an insurance company, but we have a lot of clients who are fortunate enough to have long-term care insurance, and that can be a very effective way of paying for your long-term care. It's debatable as to when somebody should start applying for long-term care. I have heard it said, though, by a financial advisor that at age 60 is when you should start applying for long-term care, because if you have it at age 50, then the premiums you pay for those 10 years, for most people, they can be not money well spent, but if you apply at age 75, for example, for long-term care insurance, your premiums might be too high. Anyway, a financial advisor I've heard say that when you turn age 60, you should start applying for long-term care insurance. And of course, if the premium is too high, too expensive for you, or your health just isn't going to work out to qualify for it, then so be it. But at least you could try to apply. And then Medicaid compliant spousal annuities, that is definitely too complex to talk about today, but that is one of the things that we do. It essentially turns some assets that a married couple has into an income stream that will benefit the healthy spouse, assuming the healthy spouse lives for the entire duration of the annuity. The reason it's Medicaid compliant is if this healthy spouse does not live for the entire duration of the annuity, then what is left in the annuity goes to the Medicaid program. So that is what that's talking about there. Something our firm does not do, but there are some law firms that do is it's aid and attendance from the VA. Currently, our firm does not do that, but that is a source of, can get some additional income that can help pay for some in-home care or some assisted living care, or even for some long-term care. If you are a VA veteran, then and you apply for Medicaid, the Medicaid program will at least want to see that you've applied for any aid and attendance that you might qualify for. For the most part, is to be a VA aid and attendance recipient, you have to have served at least one day during a period of wartime. Or if you are a spouse of a deceased veteran, that you might also be able to qualify for some money and aid and attendance. And of course, you want to maximize your Social Security. For many people, of course, they have to apply for Social Security the very first day they're eligible, and for the rest of their life, they generally get less money per month. There's other people who stretch it out all the way to age 70, so they do not get any Social Security for that 8-year period between 62 and 70. But when they get it at age 70, they're getting more per month. So everybody, depending on, frankly, how long you expect to live and what other sources of income you have to decide when exactly you're going to be applying for Medicaid or applying for Social Security. So that was a very quick rundown or going over of what long-term care is. Hopefully that helps you get some broad overview information. But if there's any questions anybody might have on this topic, I'd be happy to take some time here for that.
Okay, thank you so much, Attorney Winger. And you have several questions in the chat. And the first question was actually put in the chat when you were going over what to know to qualify for benefits. And the question is, so going back to income, they cannot take pension or income from community spouse to pay
Oh,
for
that's the one that's not an aid. So
the ill spouse. Did I hear that correctly?
it's not.
I'll try to answer that. But if it is income of the healthy spouse, then no, Medicaid cannot take income from the healthy spouse. No.
Okay, so you did get to hear the question.
Yeah.
Okay, so next question. And this question was during the Medicaid planning. Does the caregiver exception only apply to children? What if no children, but nieces that move in and provide caregiver support?
No, I do not believe it applies to nieces or nephews. No, unfortunately.
Okay, and the third question was also during that same time frame about Medicare planning. Can you put your home or assets in a trust? Are you eligible for Medicaid?
So this is very important. So that's what I was talking about with the irrevocable pure grantor trust. For example, a much more typical revocable trust will not help you at all for Medicaid. Most people, when they're thinking about doing a trust, want to do a revocable or amendable trust. That will not work for Medicaid. No, so it has to be specifically an irrevocable trust.
Okay, and the next question is, do you know if the spouse of a living veteran can qualify for aid in attendance?
Generally, no. As a general rule, it's an unfortunate aspect of aid in attendance is if the veteran is still living, unfortunately, the ill spouse cannot. No.
This last question, I'm not really sure. The person has house, families just say, plan to return home. That's it, question mark. Could you unmute yourself and ask that question or put a different question in the chat? Okay.
Well, I'll try to take a crack at it. If there's even a 1% chance, even if it's just an aspiration that you want to return home, then you state on the application that you intend to return home. Of course, it might never work out that you actually return home, but you at least state that you intend to return home. It doesn't really necessarily matter how unrealistic it is, but in order to exempt the home under that, you need to at least say that you intend to return home. Most people who go into a long-term care facilities, they at least want to return home.
Okay, so I think that was Ms. Long that unmuted herself. I just muted her so she could hear what you were saying, but Ms. Long, you can go ahead and unmute yourself again.
Okay, so I just wanted to make sure, remember the family is the one that's applying for this for most individuals. So the family would just say the patient plans to return home on the
Absolutely.
application.
So if you say that if the patient does not intend to return home, then the home will not be exempt.
Okay.
Thank you.
Yep. Sure.
So does anyone else have a question for Attorney Winger? If not, I would like to ask you to take this time to write down the phone number to Byrd and Byrd, and that's 301-464-7448. And we thank you for your time again for a very informative session. And again, I could never thank you enough, Attorney Winger, and you all have a great day.
All right. Well, thank you very much, everyone. Have a great day.